Good afternoon, everybody, and welcome to our civil rights event. I'm Pat Quinn. I'm the managing partner of Cadwalader, and I want to thank everybody for coming. This is, I guess, the third event in our fourth year of our civil, but it's the second one we've done completely virtually, and so thanks everybody for finding your way to us. For those of you who have joined us before, then you know that the content and conversation in these events has been pretty remarkable. If you're here for your first visit, thank you for joining us, and I think you'll see what this is all about. We developed the Civil Rights Series as part of our, and it's sponsored by our Cadwalader Center for Diversity and Inclusion. And although you may not think of an event like this as a traditional diversity and inclusion event, these events actually have been quite key to our efforts to build at the firm a diversity-friendly environment where important civil rights and social justice topics, there's a forum for discussion about these important topics, and an atmosphere where people want to hear about and understand and think deeply about topics like the one we're fortunate to get to discuss today. It's hard to imagine a more important topic for discussion given recent events, but not just, unfortunately, not only recent events that have been going on for way too long, and that is the role of the excessive force that appears in policing all too often. We're really lucky today to have three experts to lead our discussion on the topic today. We are very pleased to be joined by Woody Connette, who is, among many other things, the attorney who represented the plaintiff in kind of a watershed case in this space, Graham versus Connor, which was the first case to apply the Fourth Amendment concept of reasonableness to the use of force in policing. Karol Mason is also joining us. Karol is the president of John Jay College for Criminal Justice. And Ed Chung is also joining us. Ed is the vice president for criminal justice reform at American Progress. So I want to give a big thank you and a real appreciation to our three speakers for joining us today. I'm really looking forward to the discussion. But with that, I'm going to hand it over to my partner, Ann Tompkins. Ann's a partner in our white collar group here at the firm and is also the partner sponsor for the Cadwalader LGBT network. And Ann is going to give a fuller introduction of our panelists.
Thank you, Pat. I appreciate it. And thanks to everyone for being here today. As Pat said, this program today is very timely. Even in the middle of COVID and quarantine, we have recently witnessed, and maybe some of us have participated in, a national grassroots call to action for racial justice. And a part of that call for action has been focused on police practices and policies triggered by the killing of George Floyd by the Minneapolis police. Over the years, as Pat said, we have seen these cases, Michael Brown, Tamir Rice, Eric Garner, and many, many others. And we wonder, how can this keep happening? What is the standard by which police practices are judged? How is it that it feels like there's a lack of accountability? So that's what we're going to explore today. What's the state of the law? How did we get here? And where are we going? So we have an amazing panel to talk about where did we begin with this Supreme Court case and where we are now. So I'm honored to introduce three people, all of whom are my friends. First, Karol Mason. Karol's the president of John Jay College of Criminal Justice in New York City, which is a national leader in the education of police officers and others in the criminal justice system. Karol is a former Assistant Attorney General of the United States, served in the Obama administration, where she led the Department of Justice Office of Justice Programs and was a national leader in criminal justice reform issues such as bail reform, prison reentry, and juvenile justice. She's also a former Deputy Associate Attorney General in the department and a former partner at Austin & Byrd. Ed Chung is the Vice President of Criminal Justice Reform at the Center for American Progress in Washington, D.C., which is an independent, nonpartisan policy institute. Ed's work focuses on issues of fairness and equality in the criminal justice system. Ed, before he was at the American Progress Institute, Ed was at the Department of Justice and worked with Karol Mason at the Office of Justice Programs. He was also a trial attorney in the Civil Rights Division, where a part of his caseload included excessive force cases by the police. And finally, Woody Connette, a fellow Charlotte lawyer. Woody has been a leader in the Charlotte bar for over 40 years as a litigator. Woody is also a leader in access to justice issues in the local bar, where he's known for his professionalism, his marathon running, and the fact that he has climbed the highest point in all 50 states. That is not what Woody is here to talk about today, however. Woody is going to talk about the case that set the standard, that is the name of our program today, the reasonable officer, that has been used since 1989 when that case was decided by the Supreme Court. So before I turn it over to Woody, I'll just remind you one more time to make sure that your lines are muted. And if you have questions, you can submit them via email to civilrights@cwt.com. So Woody, I'm going to turn it over to you, and you can take us back to 1985 and how this all got started for you and for the justice system.
Thank you very much, Ann. It's really an honor to be here, and I appreciate being part of this program. I think the main reason I'm here is that as a young lawyer back in 1984, I took on a case with no appreciation for what I was getting into. I had worked as a legal services lawyer for several years, but then with two other legal aid lawyers left and started our own law firm. And we would take anything that came through the door. And one day, who came through the door but D. Thorne Graham with this heartrending story of how he had been having a diabetic insulin reaction. So a friend of his took him to a local convenience store to get some orange juice just to counteract the low blood sugar. There was a line in the convenience store, and so Mr. Graham puts his orange juice down on the counter, runs out, jumps in his friend's car, and they head out. There was a police officer parked in the parking lot also, Officer Connor, who saw them leaving so quickly, and it aroused his suspicion, and so he followed them and pulled them over. Mr. Graham, in his insulin reaction, is worried about his health. He gets out of the car. Officer Connor has called for backup, and before you know it, 4 other police officers have arrived. It got dicey, to say the least. And before it was over, Mr. Graham, who was semi-comatose at the time, was handcuffed and ended up having his face smashed into the hood of his car, his foot broken. And in the midst of all of this, they finally figured out that nothing untoward had happened at the convenience store. They had no reason for suspicion, no reason for a stop or an arrest. And here they were with this guy in handcuffs with a broken foot at this point. So they just drive him a few blocks to his home, lay him out in his yard, take the handcuffs off, and let him go. Sounded like a pretty good case to me. And so we filed it in federal court. I learned later that's not the norm here in Mecklenburg County. But as a legal aid lawyer, I loved being in federal court. I saw constitutional violations under every rock. And to me, this was a 14th Amendment due process violation. I'll confess I never considered either the 8th or the 4th Amendments as bases for Mr. Graham's claim. It smelled bad, it looked bad, so it had to be a substantive due process violation, and away we went. So we go to trial, we put on our evidence, and at the end of our evidence, the case is dismissed on an oral motion for a directed verdict. The judge ruled that I had failed to show that the police officers had acted maliciously for the purpose of causing harm. In those days, there were cases through most of the circuits saying that the standard was essentially an Eighth Amendment standard that required either sadistic or malicious intentional conduct. No way could we show that kind of thing, so we appealed. It was affirmed by the Fourth Circuit Court of Appeals, and from there, a petition for certiorari was filed in the Supreme Court by a good lawyer friend of mine, Jerry Beaver, also from North Carolina. As a little side note, at the time that we were seeking cert from the Supreme Court, there had been a dissent from the Fourth Circuit decision by Judge Butzner, who laid out very clearly that he felt that the basis was Fourth Amendment unreasonableness. And one of Judge Butzner's clerks, a fellow named Wilson Freyamuth, wrote a law review article called Rethinking Excessive Force that was published in the Duke Law Journal and used as a hypothetical our facts. So we felt like going into the Supreme Court when cert was granted that we at least had a leg to stand on. So ultimately, in the Supreme Court, of course, it was a unanimous ruling in our favor that what we had to show was simply that the officer's conduct was not objectively reasonable under the totality of the circumstances. At that time, from a civil point of view, we thought of this as a major victory, a huge milestone for folks like Mr. Graham, who were suffering from excessive force or even the types of senseless murders that we have seen in the years since then. But it's turned out that, as all of you know, the Graham case has been used more as a shield by police officers than as a sword by civil litigants like Mr. Graham would have been. So that's how we got to this point where we are today in this seminar. So Anne?
So yeah, let me, so you said, Woody, of course it was 9-0. There may be some young people here in the audience who didn't know that the Supreme Court could actually decide something 9-0. So I just thought I'd make that note. But so I wanted to throw it over to Ed and ask Ed, at the point when, when Woody's case ends up a 9-0, a reasonableness standard from a legal perspective, would that have given potential litigants cause for optimism that in bringing excessive force cases against the police, that they'd be in a much better position to have a winning argument? And what happened?
Yeah, I think the key that Woody talked about was what the standard was before, the Eighth Amendment standard of malicious and sadistic. So you had to prove, and you still have to prove under the Eighth Amendment cases. And right now you're talking about cases where the litigant or where the victim in the case is somebody who is in prison. And so whenever you're talking about corrections officers who use excessive force or deprive somebody of what they need and what's reasonable or what they need in a prison to live, those are under malicious and sadistic under that standard. So this is a considerable step in the direction that Woody indicated, where you can hold more officers accountable. And I think some of the things that Woody mentioned in terms of how it is now used as a shield in a lot of ways is as a result of how narrowly the courts have been looking at what the reasonableness factors should be. Because if you actually look at the case, and I hopefully we'll get into this later on, there were a few factors that were listed out, but it wasn't a closed off list. There were many more things that can and should be considered when you're talking about reasonableness, and especially in light of where this country is going when it comes to policing reform. And so, again, based on where Woody started, with the Eighth Amendment analysis and moving towards a Fourth Amendment reasonableness standard, certainly it allows for more officers to be held accountable for wrongdoing.
So just to circle back, so we now have a standard after Graham versus Connor of a reasonable officer. So reason for optimism because we have an objective standard. But just to talk about some of the cases and how that was ultimately defined, like reasonable when and reasonable against what standards. So how did that case law begin to shape itself in ways that were maybe unexpected?
Yeah, some of the things, and Woody, I'd love to hear your perspective on some of these as well. So some of the things that have happened regarding kind of limiting. So the factors that I believe that Judge Rehnquist laid out were what the person who was arrested or being detained at the time, what they were, how dangerous that person is. And so that's been in a line of cases interpreted or in a way that kind of puts that over the top. Where a person, for example, has been, resisting, and how resisting is currently defined. And these are a lot of fact-based issues where, if an officer testifies that the person is kind of tensed up in a certain kind of way, that's resisting. And so that allows you to use force in that could be considered excessive in a lot of situations. Or when somebody is saying, give up your hands, when you're trying to arrest and put handcuffs on them, but you have 4 people on top of you and the person can't do anything, then there are, punches thrown. We've seen fact patterns of this, not only in cases that have been decided, but others that have, that are continuing through the courts, where punches are thrown in order to get this person to comply. And so the fact of the dangerousness of the person who is being arrested, how much the court really into consideration there, I think is something that we've seen throughout case law. Woody, I don't know if that's something that in your practice and what you've seen has been, or if there are other factors that are more relevant.
One of the things, Ed, that you say that strikes me is we talk about the dangerousness of the person, yet one of the, I think, hallmarks that has caused people to react as they have is, you have people sleeping in their car in the drive-thru, which doesn't feel dangerous under any standard. Michael Brown walking down the middle of the street. So that's the part that I think that I'd like for you guys to discuss. It's not what the citizens look at is how did it start out being a counterfeit, bill exchange, and it ends up with a dead person, or sleeping in a car, walking down the middle of the street, or selling loose cigarettes, or the list goes on. That's not a dangerous situation where we would think that would cause for an escalation of police response. So how did it become reasonable to go to a call for service, even going back to Woody's case, where you see a person who's acting in a way that doesn't seem normal, and he ends up being beaten up by the police? So how do we get from reasonable to it becomes reasonable that some of these outcomes happen?
Well, I'll start here and say I think the focus, so it wasn't only the dangerousness of the individual, it was what the officer, so this is the subjective aspect of it, so that you don't go back. And I think that's one of the big changes that happened with Graham v. Connor. So it's a subjective, objective, reasonable test together. So when I was in the Civil Rights Division, when we were prosecuting these cases, you had to show not only was it you can't show, and this is from the case and the prosecuting afterwards. So it was also the fact that you can't play Monday morning quarterback. You have to look at under the circumstances what the officer was facing and what the information that officer had. So let me give you an example of some cases that I looked into where if, for example, there's a call call to respond, and the thing that gets into the officers or that is communicated to the officer is from 911, and there is either, the person may be armed and dangerous, or there is lack of clarity where the person is armed and dangerous. That information gets communicated to the officer, and then the officer then reacts in a particular way. And so that information is always presented as a defense of, if, in terms of whether or not the action is reasonable. The office, there will be testimony from other witnesses saying, "Oh, this person, we didn't know. The defendant didn't know. The defendant in an excessive force case didn't know if if the person was armed, didn't know how dangerous was. There was the potential offense that the victim was going to be detained for, and all of that, whether it's like burglary with a person who is potentially armed, we don't know. That all under Graham now, with the subjective, objective, reasonable test here, comes into play to allow the officer then to say, these are the circumstances that I was facing. You then, as a jury, have to consider those things, not whether or not all of the other circumstances could have been done better and policing could have been improved, and you could have had a different type of response, whether it's a police response or something else. It's only what the information that the officer has and what that officer did with that information that can be judged by the jury. And I think that has provided a lot of leeway in terms of what the officer says what the officer says his or her information was when responding to a particular situation. These are very complicated fact-based issues that allow for this reasonable objective test to be broadened because there are so many permutations of these different types of facts.
So Karol, talk to us from your perspective or your various perspectives. How has this case been used in police training to give police officers some bright lines about what they're allowed to do or where the lines are for their responses in different circumstances?
So thank you for the opportunity to have this conversation with some people that I'm learning a lot from as well. Back when we were all at DOJ, I remember that PERF, the Police Executive Research Forum, tried to put in some new policies or get people to embrace new policies about use of force. And that was my first introduction to Graham v. Connor, because the police leaders in the room were all talking about Graham v. Connor, and that was, again, their focal point. So when I got the opportunity to be the president of John Jay College, which was started as a police college, and the majority of our graduates go out into NYPD and law enforcement offices across the country, departments across the country. I now see an opportunity to rethink at least what I'm doing with the students that I'm educating, who are going to go out and become future officers, and also using John Jay as the convener to have this kind of conversation, because the question to me is, the two real lawyers, I'm not the lawyer in this kind of way, whether or not if we make enough changes in policies in police departments and how we train officers, whether we can then begin to change what is objectively reasonable for officers in particular situations. So, when you see what happened with George Floyd, I find it difficult for anybody to figure out how that was a reasonable by anybody's standards. And I think what helps and what helped in Minneapolis is that they had changed their policies, and they said that if an officer see an officer acting inappropriately and you don't intervene from a policy perspective in the department, that's grounds to be terminated, which is what they used for the 3 other officers. And so my hope is that if we begin to get officers to change their thinking about how they encounter people and what the goal is when they encounter people, that we can begin to change the people's understanding of what that subjective objective test means. And so for me, what I'm hoping that we can get to in a national conversation is starting with the premise that sanctity of life is your starting point, and that officers ought to be educated and prepared to think that everybody ought to be able to leave the situation alive, as opposed to them thinking about just leaving themselves safely. And so I think that, when you mentioned the situation, George Floyd was a counterfeit $20 bill. In Atlanta, my hometown, fell asleep in front of a Wendy's. And those officers had just been trained in de-escalation techniques. So for me, the question isn't just, have we trained them to de-escalate a situation? You got to reprogram and rethink the culture about what ought to happen in every encounter, and getting people to think that in every encounter, unless somebody's life is really at risk, everybody ought to leave safely. And I know there's a lot of debate, and there's a lot of legislation about saying whether the force was necessary. I worry about that without the accompanying change in culture and practice, because that becomes another vague standard that's going to become subjective. Well, was it necessary? I thought it was necessary because I thought my life was at risk. But if you're thinking about what are the situations, what's the situation you're encountering, and how can we all leave this alive? I'm hoping that would begin to change the subjective nature of the objective standard about whether the response was reasonable or not.
So Ed, from a boots on the ground perspective, what do you think about, you're coming at it from a legal perspective, and Carol's coming at it from an education perspective. Woody comes at it from a representation. I mean, is this a long-term solution, or is this something that can happen now if people want change now?
Woody, I'll let you start with this one.
One thing that has really struck me about some of the more recent killings that have galvanized us is they've escalated from such mundane situations, the counterfeit bill, someone falling asleep in the line at Wendy's. And it's like, how did we get to this outcome? So I'm so delighted to hear Karol talking about how, we need to have as the bedrock the sanctity of life. And isn't that what policing is about at its very heart, is the comfort and security that we all expect? And if we grew from that to a culture that favors de-escalation rather than escalation, and if that's what you're trained around, and if that's the expectation in the community, and it doesn't happen, then it makes it harder for officers to argue in their defense that they were looking at this little microsecond where they made the decision to fire the shots. I don't know, Ed, can you talk to that some?
Yeah, I that's exactly where I was heading as well. I think you're pointing out the fact of the kind of that microsecond, and I think this happens both from an individual incident-based analysis, and also how a department reacts to this altogether. So if you look at the George Floyd case, and thanks for bringing that up regarding the fact that the call for service here was one for a counterfeit $20 bill, and I watched the video, the multiple videos. There are multiple trigger warnings here, so if you haven't watched it, there's obviously some disturbing footage there. But if you look at what happened from beginning to end, this is not something that happened instantaneously. This was drawn out over several minutes, including obviously the minutes that Officer Chauvin was on top of George Floyd along with two other officers. But there were multiple incidents or multiple times during that entire encounter where things could have changed, and that Officer Chauvin or any of the other three officers, a couple of whom were really new to the force, could have changed the trajectory of what's happened and intervened and stopped that. And that happens in the department as well. And so I think one of the things that I think Karol's been working on, obviously at the college, and a lot of folks in the justice reform space have been working on, is what are the things in the department level that you're looking at where you could have intervened and stopped this situation, stopped an officer getting to the point of feeling like it's okay that you could have your knee on somebody's, the back of somebody's head, neck for that long of a period of time. Derek Chauvin, the officer, had 18 complaints against him. Only 2 were just found to be sustained. And obviously he was still on the force at the time of this happening. And so there are these types of instances throughout an officer's career that where some types of interventions need to happen, some types of policy changes. And that's why, for us at the Center for American Progress, our focus has never been about bad apples. It has always been about departments and department policies and changing department policies, as Karol was talking about, because bad department policies and trainings that don't keep officers accountable can have good officers do bad things. And so in that continuum of things, I think it's really important to consider what the policies are, what the training is, but also especially what level of accountability there is, not only up until when it gets to a point of a death resulting incident, but even the ones that are less serious than that.
Yeah, and can I add something to what Ed was saying? So what's interesting when you talk about good officers can wind up in bad situations. I'm not sure how to pronounce his name. On one article, they said pronounce it King, but one of the officers in Minneapolis who was a new officer, he joined the force because he wanted to change how police respond to communities of color. And he winds up in this situation. And so you really have to figure out, my hope is that if we have a culture change within departments and accountability, that again, that shifts the question of, was the action reasonable? If it becomes expected and understood that if you behave a certain way, that is not reasonable and you will be held accountable, if not necessarily criminally, but you can be held accountable within the department, and that the department itself honors its policies and holds people accountable. And that's the challenge. So one thing that Ed and I have been dancing around is when we were at the Department of Justice, we pulled together some money and created something called the National Initiative to Build Community Trust and Justice. And there were 6 pilot sites, and Minneapolis was one of those pilot sites. And the goal of this initiative was to make sure we never had another Michael Brown situation again. And so every sworn officer in that department and every civilian employee in that department received procedural justice training, implicit bias training, and they went through a racial reconciliation project. All of these were theories that well researched, and we decided to test them out in certain communities to see how they work together if you brought these concepts into the department. So for me, when I saw what happened with George Floyd, and I refused to use that other officer's name, when I saw what he did with his hand in his pocket, knowing he was being filmed, with just, no fear of any accountability, I felt like our work had failed. But I don't feel like we fail. It just demonstrates how hard culture change is. And so when you couple the work that we had done in that department, the one success out of that story was the other 3 officers got fired because of our work. They put in a policy that if you didn't intervene, you could be fired. And that's what gave them the room to be able to fire the other 3. But when you've got an officer who went into the department to try to change the dynamics between communities of color and law enforcement, and this happens anyway, it means that we've got to just redouble our efforts and really think about what it is we're trying to accomplish. And I think that we've got to get back to not just thinking about de-escalation, but again, what are you there to do? Communities need to really take a step back, which at John Jay, fortunately, I've got the money to lead some conversations about take the issue away from police use of force and what police ought to be doing. Is let's redefine define what public safety is. Who's got a responsibility in creating those safe communities? And then what role do police play in that? Because the reason why we get a lot of these calls to police are because we haven't invested sufficiently in mental health. We haven't sufficiently invested in things that would reduce the number of calls that police officers get called into. Then you could start focusing on, okay, when police officers are engaged and do need to be engaged, how are we making sure that they frame that encounter in a way that everybody, it maximizes human life?
So, Carol, you're talking a lot about changing culture. I mean, should we lawyers not be looking for a legal out here? Ed, you talked about the totality of the circumstances. Within the Graham case, is there a place for a legal change for some of these cases that are going to be heard? I mean, the George Floyd case will be heard under Graham v. Connor. And so how would you tweak the argument to try to change the outcome in this and some of the other pending cases? And Woody, I'd love to get your point of view on that as well.
Yeah, Woody, I defer to you first, since you I mean, you were the expert on this particular case, and then I'm happy to come back with some of my thoughts too.
Can I ask a twist on Ann's question to give Woody a little bit? So if I understand Graham v. Connor's decision, you went in on a 14th Amendment argument, but they came back with a 4th Amendment analysis. Does that mean that the 14th Amendment argument is moot? I mean, can we still try to make those kind of arguments?
Conceivably, you could. I think that one thing I'm recalling from the Supreme Court opinion is that, particularly in the concurrence, that they did not necessarily rule out other bases. So there might be room for someone to go in and do a substantive due process claim. But I think that there is, at this point, so much case law that has been built around Graham versus Connor in the years since the opinion came out that it would be hard to go back and put all of that aside and start with something new. I'll confess, through the years, I've lost a lot of sleep over this. I'm wondering, how do you articulate a different standard? And I just haven't been able to come up with anything. I think that there does have to be a standard for courts to apply, whether they're looking at a civil litigant like Mr. Graham or Mr. Floyd's estate making a claim, or on the criminal defense side where you're prosecuting a police officer. There needs to be a standard, and I wish I could figure a better way to articulate it.
I think one of the things that, sorry, go ahead, Woody, I apologize.
I'll just finish up real quickly. I sometimes think of this standard as roughly analogous to the standard you would apply in a medical malpractice claim. What do you expect of a surgeon who encounters something unanticipated in the middle of a procedure and they have to make a quick decision? How do you judge that surgeon's performance? And it would be articulated in roughly the same way. You look at what's objectively reasonable based on the knowledge, experience, and training, and what other surgeons would have done under similar circumstances.
But it's an interesting point. You say it was unexpected, but if you look at the two recent cases, what happened in Georgia and what happened with George Floyd, it wasn't unexpected because of the way they let things. So if you use that analysis, which I think is a fine analogy, I still think there's room to say, but here it wasn't an unexpected result because
Carol, you're absolutely right, Carol, and that's one of the things that is so distressing to me is that it's just carried out over such an extended period of time. It's not like there's a split-second decision being made, and it's the officers who are ratcheting things up, and that's what bothers me. I think it's what really has caught other people's attention as well. It's just really tragic.
I think one of the things that we're looking at here, and just to read specifically from the decision, it says, however, its proper application, this is the reasonableness test, requires careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of officer or others, and whether he is actively resisting or attempting to evade arrest by flight. I think one of the key word for me there is including, because it shows that these are three of other factors that go into the totality of circumstances determination. And one of the things that I think we need to look at that the court didn't look at, the court only looked at what the person being arrested was doing. The court, in those three things, we're talking about the severity of the crime that the person who was killed or force was used against that person, whether the suspect poses an immediate threat, and whether the suspect is actively resisting. It says nothing about what the officer was doing at that point. And to your point, Woody, and to Carol's point, the reasonableness test has to also be what is reasonably expected of that officer in those circumstances. And so what's happened thus far, and I think Carol alluded to a lot of this, was in several states and several police departments, the de-escalation, the kind of this duty to do no harm as much as possible, things like you can't shoot at a car that is, or a person that is fleeing. Those things are starting to become ingrained in at least some police departments, and hopefully in the longer term in police departments. And so even if somebody is faced with a circumstance where the severity of the crime is high and the suspect poses some kind of threat, that can't be the entirety of the totality of the circumstances evaluation there. One of the other things to point out here is that as you're, one of the things in the cases that I prosecuted, we would see at the Civil Rights Division often the defendant bringing in a use of force expert that really doesn't have any idea what the officer was trained on, or the specifics of what is expected of that officer. It's much more, I looked at the video, if there was a video back then, 10, 15 years ago, and I looked at the circumstance, I looked at incident reports and testifying about what a law enforcement officer should do at that particular time. But in this situation, or in current circumstances, there are so many differences in terms of how one police department, who that may be more small p progressive, it's what they expect of their officers. And so, a use of force expert that really doesn't have that background probably should not be able to testify as an expert in that particular case. And those are things in, in motions eliminate and others that can be argued. But I think specifically what we're trying to figure out is, can we expand the definition of what a reasonable officer or what this analysis in the totality of the circumstances should look at to include the officer, not only the person. Sorry, and I will say this, one thing I want to just piggyback on Woody's comment real quick about surgeons and Carol's perspective of broadening what public safety means. I think that plays into a lot of this. And one of the things quickly that we have used as an analogy is public safety is very much like the medical, where law enforcement should be the surgeons that now in modern medicine, surgeries should be the last resort unless there's a major problem. And you should try to do everything else outside of that to be preventative and to have healthy lifestyles so that you don't get to the point of a surgery, or even the outer rung outside of that, you don't get to a point of having to have interventions at all. So, I think policing, public safety should look at that and really focus on the investments, as Carol was talking about, that talk about how to maintain a healthy community, just like we need to maintain and I'm certainly not the poster child for this on the physical health side, but on how we maintain a healthy lifestyle so that we don't have a situation where surgery is needed. Because as we know, surgery is very invasive. It takes a long time to recover from. There's significant rehabilitation, and you have lifetime effects of of the consequences of that surgical intervention. So I think, just combining the two thoughts together, I think as much as we can reduce surgeries and law enforcement and criminal justice interventions, the better our communities and our criminal justice system will be.
So I'm going to borrow that analogy. I love that. I was going to say that's one of the reasons that I was excited to be on this call, because it's it's a helpful framework to really be thinking about, while the Eds and the Woodies and you guys are taking care of the legal aspects of things, the litigation side of things, I want to rethink our education model for people going into policing so that we can minimize these kinds of circumstances ever happening. I like to say that I'd like to think that no John Jay graduate would have been any one of those 4 officers, because they would have had the moral courage to speak up and stop it.
It's so encouraging to hear you saying that, Carol, because to me, the training and that we give to law enforcement officers and the policies that are adopted by police departments have to become an integral part of what we think of as reasonable when it comes to the conduct of an individual police officer. And that's particularly true if your guiding principle is, Carol, as you said earlier, the sanctity of life, and that no one should go away from the encounter less healthy than when they went in.
We've been talking about the case law and from one perspective, and I wonder, so the issue for me is, how are you going to change behaviors? People need to be held accountable. Because when you look at that officer whose name I won't say, with his hands in his pocket, knowing he's being filmed. So what are the other levers of accountability that we've got? Because you're only going to change, you also need people to realize there are going to be repercussions for their behavior. And putting them in jail is not the only repercussion. There ought to be other things on the spectrum. I know, Woody, that your original case was trying to get some compensation for Mr. Graham. I'd like to think that the case law, on the spectrum, that people and juries are more willing, if you're talking about other ways of holding them accountable versus taking their liberty, that there might be some more room.
Yeah, Carol, I'm glad you made that last point. I have sometimes wondered what would Graham versus Connor have looked like if it had gone to the Supreme Court as an appeal in connection with a criminal prosecution of a police officer. What would they have said about the standard, rather than having it go before the court as a civil claim for damages?
And what do you think about that, Woody?
I don't know.
Me neither. Well, when your case came back, Woody, for retrial after your 9-0 win at the Supreme Court, what happened?
Oh, we lost. Yeah, we did a retrial. Just as a side note, there was never any kind of offer of settlement. There was never any serious settlement negotiation. This was in the days before mediation. And so poor Mr. Graham had been in and out of consciousness through the entire encounter, so he wasn't able to testify really as to what happened. He had as a witness his friend William Berry, and William Berry could not say which officer had done what or who had said what, and so we lost. It was also in the days before body cams. I wonder if there had been body cam footage, would there have ever been any kind of case to begin with?
It's interesting that you bring up body cams, because I think the idea behind body cams, policy idea behind body cams, was to change police culture by making sure that there was accountability by video. But I don't think that, maybe there's a reduction in police violence, but I don't know. It doesn't seem to be a deterrent. What do you guys think about that?
Well, part of the issue is, and Ann keeps raising things that Ed and I were integrally involved with the creation of them. When we were led to put out more money to buy body cam, but give police departments body worn cameras, I was reluctant to do it at the time because we needed some more research. And I think we needed some more work on just having the cameras is not enough. The question is, what do you do with the footage? And the cost is not, for the departments, is not in the cameras themselves. It's in the storage and the time in using the footage to analyze it. And so if it's being used properly, somebody ought to be reviewing that footage on a regular basis and using it as a teaching tool within the department. So you can reinforce what's good encounter, and then you can hold people accountable and train around what's not a good encounter. What we do know from the research that has been done is that it has impacted behavior on both sides somewhat, because everybody knows they're being recorded. Again, the question is, are police officers using it appropriately and keeping it on, and is somebody watching the film? But it's been used as much to protect officers as well as hold them accountable. So I think that my question is always, I don't know why we don't all behave as if we're on camera, because we are. Because as you saw, the footage about George Floyd got out not because of the body-worn cameras, but because of all the people recording everything. There are cameras on every street corner, every building. And so some of this is a question to me, again, that officer acted with such impunity because he knew he was being recorded and didn't care. So it gets back to the question again about how do you make people care? I think making the jurisdiction pay. So I think that if Graham v. Connor were a trial court, a jury were looking at that today, I think he'd get some money. But I think that doesn't change, to me, the officer behavior, because they're not making the payment.
And Carol, I agree fully with you. I started at the Department of Justice in the Civil Rights Division as prosecutor in 2006. So there were cell phones there with cameras, but those cameras were just god awful, and you really couldn't make anything out from that video. It's like kind of looking at CCTV type of thing. And if I was a line prosecutor now, I would love to have body cameras. I would love to have footage of from cell phones and so forth, because the cameras right now are amazing. But I fully agree with you that I think part of this is, what policies do you actually have in the department of how to use them? And then how are you holding them accountable if they accidentally or purposely, shut off their camera and it just doesn't happen to record some situations? I think we have seen situations, even something as not as serious, but for example, people who have kept their body cameras on and the audio part on, and they're recording some very racist conversations that has led to the firing of officers, or people who thought that the camera was off, but they are shown. For example, there were cases in Baltimore of planting evidence in drug cases, and so I think generally speaking, it continues to be something that is helpful and promising, but with all of the caveats that Carol was talking about.
Let me see if there are some questions that have been submitted by the audience. So Aisha, any questions for the panelists?
Thank you, Anne. Yes, we have a couple questions, and I will say that you all as panelists have done such a good job that you're actually answering a lot of the questions that we're getting. But one question that we have for Woody specifically, Woody, the question we have is, what was it like to be in that room and space with the Supreme Court when this case was argued? And in particular, someone asked, what was it like to argue, to be in the space when the argument was taking place with Thurgood Marshall in the room, and what his reactions might have been like?
I was at the Supreme Court argument happily as a spectator. And one reason I was there as a spectator is because I had framed everything up as a 14th Amendment case, and here we were arguing for a Fourth Amendment standard. But it was like, once the defense started its argument, Justice Thurgood Marshall was still on the bench, and one of the very first questions right out of his mouth was, what reason was there for handcuffing a diabetic like this who was in a coma? And to me, it was like the first time since I'd first met Mr. Graham in 1984 that I had heard anyone connected with the court say anything that suggested that they got it. But here I was, clueless. I knew nothing of Justice Marshall's years that he had spent on those horrible Groveland cases down in Florida, where his clients had been so brutally attacked by law enforcement. He had been in the trenches. He got it, and I really appreciated that.
Another question we have, I think it stems from something that Karol brought up about bias training and de-escalation training. And the question is, how do we make sure these things actually go into effect, and how do we make headway? How do we ensure that officers are properly trained in implicit bias and de-escalation training?
So I think you're going to have to get my answer and Ed's answer because we may not agree. We've worked together a long time, so that's why we're doing this. I think that the challenge is when we invested in those cities in the pilot program. If you heard me say, I cobbled together the money to do it. I think that it's not a one and done. It takes constant reinforcement, holding people accountable. So the procedural justice piece, one of the things we've always talked about is it's not just procedural justice in terms of how they encounter the community, but it's also internal procedural justice. So if the officers aren't being held accountable internally for the policies and procedures, the training isn't going to do you any good. And what complicates things, again, this is why I say we need a culture shift, is I think that, I know this is public knowledge now, Minneapolis was one of our most difficult cities because they've got people in their union leadership who were out and out white supremacists. So when you got a real culture shift you're fighting against when you've got that influence in the department as well. And I think it's going to take constant vigilance, constant work, and the community demanding something different. I think that one of the things we saw during my time in the Department of Justice and leading OJP is the law enforcement leadership, the police chiefs get it and want to make change, but their hands are tied because of the union contracts that they have. They have a limited ability to hold officers accountable. And so this is where you as citizens have a right to push your mayors and your police departments, look at those contracts and look at how you're going to allow your officers to be held accountable. So it's not, we own some of this as well as citizens, and we've got to start using that power that we have.
I agree completely, Karol.
Oh, can we record that? I want that for later.
The only thing that I'll add to this is I think Karol, about Minneapolis, the chief there right now, Chief Arredondo, is a really, really forward-thinking, good chief. He was the second chief that we worked with there and really implemented everything that we're talking about, trainings, de-escalation, all these policy changes and shifts and so forth. You saw, as Karol mentioned, that he took quick action and fired his officers right after the incident. And I think what it shows you, as Karol was talking about, was how deep culture is. And police chiefs last on average 3 to 3.5 years per stop, and the officers and the supervisors, the line supervisors, they stay on. And it is that kind of culture and the work that Karol's doing at the college to train the officers that are refreshing the police department, how important it is for them as they go into long careers, usually between 20 and 30 years, to be trained in the way that they are, and that, again, as Karol said, not for just have policies and trainings for the sake of it, but to make sure that there's constant accountability.
Well, on that note, I think that is a hopeful note to end on, and I thank the three panelists for what you have done and what you are doing to help change that culture. I hear a lot of hope in the conversation today that change is possible, that just because it's a widespread problem and that it's nationwide, that there is a call to action from citizens, from leadership, from within police departments. So Karol, thank you for everything that you're doing at John Jay, Ed, everything that you're doing on the litigation and policy side, and Woody, thanks for taking the case on and taking it all the way to the Supreme Court and sticking with it and losing sleep over it still, which shows your commitment to it. So we very much appreciate it. Pat, do you want to make any closing remarks, or are we good?
I'll just echo your thanks. I mean, I thought it was a great panel. All of y'all doing, putting the work in. Thank you.